My name is Samantha Knights. I'm a barrister at Matrix Chambers. I specialise in immigration and refugee law. I'm going to talk this evening about family reunion. It's an incredibly important topic for refugees. A lot of people think that when a refugee has won their case or has been given status in this country, then that's it. Everything is fine after that. But for a lot of refugees, the nightmare sometimes only begins when they try to reunite their families, with the legal and practical difficulties that there are getting families together. So that's why I want to focus tonight's talk on family reunion.
Well, good evening. Thank you very much for coming. We're very privileged to be the first of what are going to be 9 different events. And as you can see, it's a joint enterprise with Matrix Chambers, with the Middlesex University, and of course with the Law Society. Immigrants are motivated to leave their native countries for a variety of reasons. They include a desire for economic prosperity, political issues, family reunification, escaping conflict or natural disaster, or simply a wish to change their surroundings.
I do want to focus on refugees, although family reunion, of course, is a wider topic and affects migrants as a whole. But as you'll, I'm sure, understand, the situation of the refugee is particularly acute, and there are special provisions and procedures in the law for refugees.
Hi, I'm Alastair Logan. I'm a member of the Law Society's Human Rights Committee. I'm very pleased to have been part of this forum tonight. It is extremely important that people understand the human rights they have and how easily they can be lost if they're not properly protected and properly understood. So I'm glad to see so many people here tonight, and I hope that these lectures these forums do an awful lot of good and increase the level of understanding.
Both court cases were extremely anxious to stress the limited function of the courts, to show that human rights are not a threat to the government's ability to control immigration. In that respect, I think they're both very political judgments, despite the fact they're expressed in highly doctrinal terms. My name's Helena Wray. I'm an Associate Professor of Law at Middlesex University, and I'm a specialist in immigration law. I have a particular interest in family migration and in citizenship. That immigration law is one of the most complex areas of law. It changes constantly, and it operates at a number of different levels. And so anybody who is to understand immigration law has to understand it at the domestic level, they have to understand it at the European level, and they also have to understand it in terms of human rights. All of these are complex and difficult legal jurisdictions. There are many ambiguities and complexities in each of these legal systems. So actually ascertaining what somebody's immigration rights are is not straightforward. There isn't an easy solution. I think access to law is absolutely vitally important. I think the removal of legal aid from immigration cases is catastrophic in terms of the ability of people to enforce their own rights against the government.
Do you think if judges are becoming less interventionist in terms of applying Article 8, do you think we'll see more cases going to Strasbourg?
Yes, I think you will see more cases going to Strasbourg. What you won't necessarily see is more cases succeeding in Strasbourg. The Strasbourg jurisprudence on Article 8 in immigration is pretty conservative on the whole. It's quite difficult, I think, to predict how a particular decision will be decided. 2 recent cases in Strasbourg that have gone in different ways demonstrate this.